On September 21, 2019, plainclothes police officers entered the Chamalo Medical Clinic in Kilifi County, Kenya. They demanded treatment records and arrested Salim Mohammed, a licensed clinical officer, without providing prior notice to the facility. 2 days earlier, Mohammed had provided emergency care to a 16-year-old student known as PAK. After determining she had suffered a spontaneous miscarriage, he performed a manual vacuum evacuation. Police arrested PAK directly from her recovery bed in the women's ward. This illustrates the legal conflict at the center of their arrest. PAK and Mohammed were charged under Sections 158 and 160 of the Penal Code, laws dating back to 1930 that categorize abortion as a felony. However, Article 26, Section 4 of Kenya's 2010 Constitution permits the procedure if a trained health professional determines there is a need for emergency treatment or a danger to the life or health of the mother. By prioritizing the older penal code over constitutional exceptions, law enforcement replaced clinical protocol with a police investigation, treating a medical recovery ward as an active crime scene. The case eventually reached the High Court in Malindi. In 2022, Justice Reuben Yakundi issued a ruling that addressed the legality of these arrests. The court found that medically necessary abortion is a constitutional right. Justice Yakundi linked this to the broader protections for human dignity, privacy, and bodily integrity found in the 2010 Constitution. As a result, the court quashed the criminal charges. The ruling stated that enforcing the penal code without a clear framework for constitutional health exceptions violated the rights of both the patient and the provider. For a brief period, this ruling placed a clinical officer's medical opinion beyond the reach of the penal code's felony provisions, ensuring that healthcare providers could act according to their training without fear of immediate prosecution. This legal tension in Kenya mirrors recent shifts in the United States, where judicial interpretations of reproductive health care have undergone significant changes. For decades, the U.S. legal system relied on the undue burden test from the Casey decision. This standard required courts to weigh a patient's individual liberty against the state's interest. That standard was removed in 2022. In the Dobbs decision, the Supreme Court held the Constitution does not confer a right to abortion, overturning Roe and Casey. Concluding the right isn't explicitly mentioned, authority to regulate the procedure was returned to state legislatures. This shift towards strict textualism removed the legal protections that previously prevented states from imposing absolute bans on the procedure. On April 24, 2026, the Kenyan Court of Appeal overturned the 2022 High Court decision, removing the legal protections that had previously shielded patients and providers. The appellate judges held that the 2010 Constitution does not grant a right to abortion. Instead, they interpreted Article 26 as an express prohibition, with access permitted only under narrow medical exceptions. This changed the procedural reality for healthcare workers. The opinion of a trained health professional is no longer a protection that prevents an arrest. It has become an affirmative defense that must be proven during a criminal trial. While anti-abortion advocates in other jurisdictions may litigate over abstract professional concerns, Kenyan clinical officers now face the prospect of arrest and detention before they ever reach a courtroom to explain their medical decisions. By reclassifying medical judgment as a defense rather than a right, the court effectively presumes providers are guilty of a felony until they can provide proof of their medical justification in court. These shifting legal interpretations exist within a persistent regulatory vacuum. Despite international agreements, the Kenyan government maintains an official reservation on parts of the Maputo Protocol, stalling the development of clear access to safe reproductive care. This creates a lacuna, a policy void. In 2013, the Ministry of Health withdrew the national guidelines and training curriculums that health professionals use to determine when a pregnancy could be safely and legally terminated. At the same time, the Director of Medical Services threatened health workers with professional sanctions for participating in training on safe abortion practices. This left doctors caught between their constitutional duty to treat patients and a penal code that criminalizes that treatment. A constitutional exception to save a life cannot function if the state actively prohibits the medical training required to provide that care. The reality of this policy void is seen in the case of JMM, a 14-year-old student and rape survivor. Although she qualified for a legal abortion under the health exceptions of the Constitution, a lack of clear information and available services led her to an untrained person in the back of a pharmacy. The procedure resulted in severe complications and chronic kidney damage. JMM died at the age of 18, while her mother was still pursuing a constitutional petition regarding the withdrawal of the National Health Guidelines. When appellate courts prioritize textualist defenses over positive rights, they do not end the practice of abortion. Instead, they shift it into clandestine spaces, turning hospitals into investigative sites, leaving patients like PAK and JMM to face consequences of legal ambiguity.